my lord.
62?
62, my lord. In the last occasions, my lord, I sought time to file a rejoinder and in the meantime listed for hearing. There are two documents that's very important, my lord. One I got by way of an RTI this morning.
You should have.
I'm
By
sorry.
now, you should have brought it. Last time, same submission you made.
No, my lord, what happened is that it's done by RTI. So another one I'm yet to get on 5th, I'll be getting, my lord. So I'll be able to, it's a very important documents, my lord.
Yeah, for whom?
Respondent number 4.
2 weeks at the request. Don't say anything.
Obliged.
Obliged.
May I please, Your Lordship? Your Lordship, I beg to mention item number 61, Your Lordship. So if this matter comes up after 2 weeks, Your Lordship.
No objection.
What's the matter about?
Is the regularization of the service, Your Lordship.
No, it's a matter where certain lands were transferred by the clan and they are seeking employment.
Okay. Yes. 2 weeks, yes.
Your Lordship, I beg to mention item number 59, Your Lordship.
Yes.
Your Lordship, the Conductor Council, he is not well. So if this matter comes up after 1 week, Your Lordship.
Mr. General.
Vicky Jindal, Your Lordship.
Okay, 2 weeks, yes.
Much obliged.
May I please, Your Lordship, I beg to mention item number 56, Your Lordship. Let this matter be taken after 1 week, Your Lordship.
Other side, you informed them?
Yes, Your Lordship.
2 weeks, yes.
Much obliged, Your Lordship.
Yes.
Your Lordship, I beg to mention item number 57. I pray let the matter come up after 2 weeks.
Yeah, for whom? For P. Bhattacharjee?
Yes.
No objection, Your Lordship.
Mr. General is not well.
No, sir.
Highly obliged.
Yes.
Lord, I beg to mention item number 58, Lordship.
Number?
58. 58, Lordship. I feel that this matter will come up after 2 weeks, Your Lordship.
I'm for respondent number 5, Lordship. I have no objection.
No one has any objection here. Always 2 weeks, yes.
Obliged.
Right, sir.
May it please, Your Lordship. Lordship, I beg to make a mention item 33, Your Lordship. 33, Your Lordship.
33.
Lordship.
All the matters will go on. 33. Why?
Lordship, senior counsel is out of station.
Connected to 33. Where's Dr. Mozika?
Your Lordship is on legs before division bench, Your Lordship.
Why you want to take time?
Lordship, senior counsel is out of station, Your Lordship.
Doesn't matter, you are there.
Lordship, senior counsel
So
is...
suppose the captain's not there and they think all the soldiers surrender and run away. They will desert their post. That's what's happening then. Captain's not there, everyone's running away. You inform him, but 33 and 32, who's 32 33, they are connected.
Yes, Your Lordship. In item 32 is a Pathak.
32 33 are connected. Correct.
Yes, Your Lordship.
Then why asking 33? You'll do the 32.
No, Your Lordship, item 32, Mr. Pathak, Your Lordship is there.
Mr. Pathak is there?
Yes, Your Lordship. V. Kumar.
Where's Mr. Pathak? After? Yes, Mr. Kumar. They're seeking adjournment 33.
32.
32 we are appearing, 33 connected matter they are appearing. Last time I think we
Yes,
would dispose it of. What to do?
2 weeks time.
Wait for some time. Wait some time. Let
One week?
Yes?
1 week may be given.
Okay, give
If
1
they
week.
want time,
1 week, yes, 1
1
week.
week.
Okay.
My lord.
Otherwise, yes.
My lord.
Much obliged, Lordship.
Lordship, similar prayer for item 55.
No objection, Your Lordship.
55, you file your affidavit, everything's ready.
We already filed, Your Lordship.
It's ready. It is that a WAF matter, correct?
Yes,
Yes, Your Lordship.
Okay, 2 weeks, yes.
Much obliged, Lordship.
My lord, I beg to mention item number 60, my lord. I'm praying this matter will be taken up on Monday, my lord, as a fixed item. My lord. It's way down in the list, my lord. So
It's already there. Wait on the list has no meaning. Wait on the list out here by 12 o'clock. It's way up ready for hearing.
pray me can be taken up on Monday.
Yes, where's Mr. Sen? Not Monday.
Wednesday.
Wednesday, Your Lordship.
My lord.
Wednesday is fine?
My lord.
Yes.
Not, I'm appearing for UGC.
Very good. Be here on Wednesday, yes.
Lordship, I beg to mention item number 49. 49.
What is the status of this case?
It's still pending adjudication before the Supreme Court.
Lordship, that will be great if Lordship can place it on the 10th. Lordship, Senior Counsel wants to appear on this matter.
Which senior counsel?
D.K. Mishra.
On the 10th?
Or the dates that was given to me was 10, 20th. Lordship.
If the matters, okay, we'll have it after. You take a date. I can't give a fixed date.
All right, Lordship.
Because court won't give fixed date because giving fixed date has no meaning also. They fix the dates and they take adjournment. Fixed date means the court has reached the files.
Understand that, Lordship.
Yes.
Lordship.
Daily list, item number 1.
Still pending?
Yes, Lordship.
As the matter is pending before the Supreme Court, this is matter after 8 weeks. Parties liberty to mention this outcome is connected. Now there won't be vacations will be there. Yes.
Supplementary list, item number 1.
Yes.
Please, Your Lordship. Lordship, the petitioner is working as the Assistant Director of Physical Education in Assistant Director of Physical Education in Nehu, Lordship.
Yes.
Lordship, what happened in this case? There was a FIR lodged against him. So on 19th November 2023, he was apprehended from his quarter, and he was taken to the police station, Maukanra police station, based of an FIR filed by the one lady, Your Lordship. Now, pursuant to that, Lordship, he was taken into custody. Now, the custody was more than 48 hours. So the petitioner was suspended. So the suspension, he was suspended on 19/11/2023. So now, Your Lordship, as per
custody even 1911 only.
Lordship, 1911.
So he is suspended with effect from 1911.
1911. Then thereafter, Lordship, he was granted bail. On 20th December 2023. Now thereafter, Lordship, on 18/1/2024, he has intimated to the university respondent about his release of the bail order, Lordship. Now, Your Lordship, as per CCS rules, Lordship, the suspension order should be reviewed within 90 days period.
6 months or 90
CCS
days.
rules. Lordship, the rules is annexed in my red
Next,
petition.
where is it?
Page 30.
Page
30. Last annexed, Your Lordship.
30 years.
Can you come to
Suspension.
31 suspension?
Yes.
Lordship, he was suspended under 10 Rule 2, Your Lordship.
10 rule?
2A,
10
Lordship.
2A.
2A, Your Lordship.
Yes.
Now, Your Lordship, the review provision is under Rule 6, 10 sub Rule 6. Next page 33. An order of suspension made or deemed to have been made under this rule shall be reviewed by the authority which is competent to modify or revoke the suspension before expiry of 90 days from the effective of the suspension, under recommendation of the review committee constituted for the purpose, and pass orders either extending or revoking the suspension. Subsequent reviews shall be made before extension shall not be period for exceeding 180 days at a time. Then sub-rule 7, Lordship. An order of suspension made or deemed to have been made under sub-rule 1 or 2 of this rule shall not be valid after a period of 90 days unless it is extended after review for a period.
Shall not, huh? Yes.
Unless it is extended after review for a period, further period before the expiry of 90
So
days.
your case is not been reviewed?
Not reviewed,
It's not
Lordship.
a suspension.
Lordship, the 90 days, period
Expired
expired on 18/2/2024.
18/2.
18/2/2024.
So it's still on suspension for
Still under
additional
suspension.
90 days already.
Beyond 90 days.
Yes, Mr. Sen.
I'll obtain instruction.
Reinstate him immediately.
No, my lord, I'll obtain. I don't know whether they have reviewed, my lord. I'll have to find out, man.
We'll have it on 2 days.
Let it come out. I'll file it, my lord. I'll just look into the records, my lord. I'll file a detailed affidavit.
No, you on Monday, because if
Monday.
if he's, you only have to come instructions. You don't need to find affidavit. If he's been kept on suspension, which is against the prevailing rules, that means he's automatically should be stand reinstated.
Lordship.
Lordship, even the Supreme Court is clear on this, Lordship.
Yes, heard Mr. M.L. Nampur in the council's petition.
Let it be on Tuesday, my lord.
No. Mr. S.N. Is present on behalf of the respondents accept notice. No further is called for. Stop. The grievance of the writ petitioner, next paragraph, is that though he has been suspended since 1911,
2023.
2023, the suspension has not been reviewed after 90 days as mandated by Rule 10.7 by the university authorities. As such, it is prayed that he be reinstated with immediate effect. Mr. S.N. please email to obtain instructions in this regard. This is the matter on
Tuesday, my lord.
That is on 6 for instructions.
Tuesday, man.
We have now, today is only Wednesday, Thursday, Friday.
Monday, I may have some room. Let it be on Tuesday.
Okay, Tuesday. This in the motion column. Yes.
Item number 2.
So we have filed an affidavit on the maintainability, Lordship.
Lordship, will matter come next week. I'll file my
Why?
affidavit.
Why you will not file affidavit?
My affidavit is ready, Your Lordship, but this cannot come to sign there. Next
For
week.
number 6.
I'll be for the 6.
Mr. M.L. Nampur submits that the affidavit has since been found to have 125. Mr. Inongbri, however, prays that some more time be given for affidavit from the respondents, 4 to 6.
Your Lordship, I'll be filing my rejoinder, Your Lordship.
Prayer is allowed. Petition is permitted to file a joinder and meanwhile, just after 2 weeks.
Also,
2 weeks.
Also, Your Lordship, respondent number 7 has not entered appearance, Your Lordship.
He's already been served.
I'll be filing my affidavit of service, Your Lordship.
Then you file it, we'll see the next year.
Item number 3.
My lord, last time, Lordship allowed the respondent to file affidavit if advisable, my lord. I thought the respondent would file affidavit, but they're not willing to file affidavit. May I pray, my lord, whether may come up next week, my lord?
Why? Today we thought we'll try to dispose it off.
My lord, I was expecting that they may file a short affidavit.
There was
on your pressure, we said, okay, we will dispose it off.
I'd like to insist that the matter be taken up at this stage itself.
Monday or Tuesday, my lord.
Okay, it's okay. You are? Very good. Mr. Kisi H. Gautam has an appearance on behalf of the respondent number 6 today. As such, the notice is complete. You want to file affidavit?
I don't think so that will be necessary.
You won't file affidavit?
It's a detail.
You won't file affidavit also?
Just that while I am only the complainant.
Fine. List the matter after 1 week.
Next week, Your Lordship?
For the orders. After 1 week, it will be Wednesday or Thursday.
Interim order may be continued till.
Interim order is there.
There's no
Some protection is there.
Interim order, if any.
Unnecessarily, orders.
Item number 4.
Panpur.
But this is an application for continuation of delay, my lord.
My lord, as per the registry, my lord, it is 1,112 days.
Have you filed your objections?
Yes, my lord.
What's your objection?
My lord, in fact, my lord has also called for the records, my lord.
Where the records are from? Why did the court call for the records?
Because my lord, there was on 14th February we had a elaborate hearing. Then the record was required because our contention was that because the court mentioned before proceeding with an ex parte order, it says that he received the notice, yet he failed to appear. Therefore, by order dated 12th of February 2019, the learned court proceeding ex parte against him. So only to see that one, because I was saying
Just
that.
check the records. You examined them.
Lord,
Which
what
order
is-
dated when? You just
12 February 2019. 12 February.
My lord,
Yes, Mr.
what has happened in this case, my lord, in the suit which, divorce suit which has been filed, my lord, the address of the petitioner, my lord, is incorrect, my lord. Therefore, I was not aware of
Then how did he appear? If that's why you wanted to see the records.
Correct, my lord. Now, when did I appear, my lord? After the ex parte judgment was passed, my lord, a review was filed. And in the review, they have admitted, my lord, that the address is incorrect.
Who filed the review?
They have filed, my lord.
Why did you file a review? When you
But
never
for
appeared in,
enhancement,
we never
for
appeared
enhancement,
in the...
for enhancement of the...
So after the ex parte order was passed, you paid the maintenance, whatever?
No, my lord.
Then?
I was not even aware. They filed the review, and in the review they stated that the address is incorrect. Therefore, the correct address is so and so. And when the review was, my lord, when notice was issued, it was only then that I received. Thereafter, my lord, what had happened is, upon receipt of notice, I, my lord, then took recourse to law, my lord, that is for recalling of the ex parte order, my lord. In the meantime, my lord, the review was also being heard, ultimately dismissed. My petition was being heard. There was some application for amendment. Now, circumstances changed, my lord, wherein the respondent remarried. Because the respondent remarried, my lord, so I am now compelled to file the appeal, my lord. Because now I am only challenging the alimony and not the divorce anymore, my lord. Because since she has since remarried. So therefore, the delay, my lord, of 1,112 days, my lord.
My lord,
I'm only on the alimony part, my lord.
What was the alimony given?
15 lakhs, my lord. 15 lakhs.
What? You're working as what?
My lord, I was convicted, my lord, and I have lost my job. I am jobless, my
Convicted
lord.
in what?
My lord, convicted for attempting to, my lord, burn her, my lord. My wife, my lord.
So you were convicted in a criminal case of
Yes,
trying to humiliate her?
Yes, my lord. And that appeal is pending, my lord, before the Punjab, Haryana High Court, my lord.
So you're convicted by the court Punjab?
Gurgaon, my lord.
Gurgaon.
So, my lord, it was during that period that I was also, my lord, in jail, my lord, and the address was also incorrect. I would have proceeded with the recalling application, my lord, if the circumstances had not changed, wherein she has remarried. Now, upon
She's
her...
a resident of Shillong.
no, my lord, she is a resident of Gurgaon.
And why is the matter in Shillong?
my lord, what happened
Their
was,
claim was that, my lord, we could not contest that also because her father was working in Cleriat, my lord, in Star Cement. We could not even contest that, my lord, because we never received notice. So it is only on alimony, my lord, and the delay is on account of I was trying to, my lord, I was pursuing my remedy under law for recalling, my lord.
Now the judgment is given 19.
yes.
2019, my lord.
90 days from there.
Yes, 90 days from.
So 90 days, that's 20. And not 20 also.
My lord, in between, the COVID period.
Okay, we
yes,
leave out the
my lord.
COVID period also
Yes,
as per
my
the Supreme Court judgment. But then, even then it's 1,000 days.
Yes. No, that is the calculation of the registry, my lord.
Where's the order? It's flagged.
If your lordships kindly have the impugned judgment, my lord, at page 50.
Second. So this is okay.
That is what my lord is saying.
Fix issue notice of third party. Fix 8 to 90 appearance. Then where the fact
no,
of appearance?
the front part, the one that I've, and yes, that one. Just top, my lord. Top.
CR put up today for appearance show cause by the opposite party but failed to take steps in spite of having received the notice.
Now, my lord,
Who's present?
now kindly have the address in the suit.
Present and presented before this court is out of counsel view to proceed the case ex parte. There's no service.
My lord, now what they're saying is, my lord, the service will be front part, my lord.
No, even then, when ex parte gets in.
Yes.
Yes.
My lord, kindly have the address in the suit, my lord.
And the second part, which my lord was just saying now, can you look at that? There's a care of superintendent of police. By then he said he was in jail. So this notice was sent through the superintendent of police, superintendent of jail, my lord. Therefore, they cannot claim now that saying that there was a wrong address, my lord.
Now, Rohit Kalia.
I'm not claiming your review says so.
No. In this divorce suit, you see resident of RZ29 Anur Nagar, Uttar Nagar, Delhi.
Yes. Yes.
Now, kindly have the review.
Yes, that is right. That is right. Now, my lord, my lord may kindly look at
argue my case.
No. Wait, Mr. Huber. Let him say it then. Okay, fine.
Yes.
What happened? Now, where's the review application?
Lord, kindly have page 55.
No, the factum of service is not there. When ex parte, that the one you flagged is the order showing that it's going as parte against the.
Lord, page 55, bottom, my lord.
1 second. 55 bottom.
The cause title, my lord. Resident of RZ/A49.
Yes.
And in the suit, it's RZ29. And my lord, this is admitted, my lord, at page 57.
It's just near about. It's a question of like, you know.
It's not near abouts, my lord. It's 29 and A49, my lord.
This does not matter at all, my lord.
It does matter, my lord. Now, my lord, kindly have page.
Will you allow me? When the divorce notice has gone to jail through superintendent of the jail, my lord. So now.
One second, we'll get you argue.
Yes.
Let's see that part first.
Yes.
That petitioner to state due to bona fide mistake, address the respondent be wrong stated in the previous divorce suit, and also reflect order dated as RZ29 instead of RZA49. Okay. Yeah. Right. Now, fine. What order was passed in the review?
Review.
Was notice issued again to you, and you received the review application that means.
Yes, my lord. Because by then the address was correct, and then also I was in jail, my lord. But it was received at home.
Okay.
So thereafter, my lord, I had filed an application.
When was the review received?
Page 63 is the review, my lord, order.
When did we receive this review?
29/7/2019, issue notice, my lord. Page 65, I entered appearance 30th August 2019.
You're already out of jail now, or still in jail?
My lord, appeal is pending. I'm on bail. I have, my lord, 50% of the sentence I have undergone.
Fine. Yes. Okay. Let's hear the objection. Now, that's the only thing is that you were the wrong address.
Yes, my lord.
You were in jail.
Yes, my lord.
And then, like after you got noted the review only, you appeared.
I appeared.
And to contest the divorce decree, that is.
Yes, my lord. For recalling, however, circumstances change wherein she remarried.
Yes, Mr. Euban. Now, what do you have to
My lord, kindly have a look at my objection affidavit, my lord.
Yes.
Objection affidavit, page 11, my lord.
Yes.
Page 11, my lord. And this order was passed on 19/11/2019. This is an order passed in the case filed by the petitioner before the court of the Punjab and Haryana, my lord. And in this one, it's May I just read very quickly? Prayer in the present is for suspension of remaining sentence of applicant Rohit Kalia, who has been convicted and sentenced to 5 years rigorous imprisonment for an offence under Section 307 IPC for having tried to kill his wife Meenakshi by pouring a chemical and set her alight. For exploring the possibility of amicable settlement in view of the divorce proceeding initiated by the wife complainant on the ground of cruelty. The complainant wife had been directed to be present in the court. The complainant, along with her counsel, is present in the court and has outrightly rejected any effort for settlement in view of the divorce proceeding having been granted in her favor. At this stage, so now what he's saying...
You mean to say that at that point of time when he applied for remission of sentence,
yes,
he is already he also aware that there was...
He is very much aware. Now the fact is saying that only after review I received the notice is immaterial. He already knew. And from
So
19...
You mean to say that from 1911, 2000 will consider date of knowledge?
Even if you consider that, from 1911 to 2012, what did he do? Nothing. And before that, my lord, we have just seen that notice which I've marked in the order sheet. Down there, my lord, it is written that service of divorce, the summon, the notice of summon have been served to him through the superintendent of jail, my lord. And that is there in the order. Maybe.
In here, in the record?
Yes, my lord. If I can assist, my lord, I just point out that page.
Where is that written? Served through the...
Just give me that. I'll just mark.
So your case is that he was aware when he applied before the Punjab Haryana High Court for suspension of sentence.
Yes, my lord. This one, my lord. My lord, this is the one, my lord. Issue notice to, this is the one. This is the issue notice issued to the petitioner, my lord. Kindly look at the bottom line of his address, my lord.
Can be another Rohit Kalia.
Yes, Rohit Kalia.
Can be another Rohit Kalia.
I'm sorry?
How? Because the address is shown wrong. It should be RZ29.
No, but by then...
A49.
Yes.
The correct address is what?
RZ A49.
Is the correct address?
Yes, as admitted by them in the review.
Why you want to seek reduction of the alimony?
I don't have the money, my lord. I don't have any, my lord, any income. The record shows, my lord, I was in jail, my lord. My family has abandoned me, my lord. I'm just working on odd jobs. She has since remarried, my lord.
But look at the kind of...
Now,
my lord, those proceedings are under challenge, my lord.
You put her through, you've been convicted that you put chemical and tried to burn her.
That is under challenge, my
From
lord.
the record, she had to go to Los Angeles for treatment.
That, my lord, is under challenge, my lord.
Now, my lord, there's the petitioner
the real
is
issues,
saying,
my lord, she set herself on fire, my lord.
No,
and the blame has come on me. But I won't go into that, my lord. That is pending before the Honorable High Court of Punjab and Haryana.
The petitioner said that I am happily married now, my lord. After he came out on parole and during suspension of the sentence, my lord, he has disturbed my marriage life. My husband, now I am staying separately from my husband. Then
You remarried also?
No, my lord. I don't have any income, my lord. Nobody will marry me, my lord.
He has disturbed my life so much, my lord. Now this one is nothing just to further embarrass me and harass me, and it's sort of a mental cruelty continuation. He's disturbing my married life. My husband, we don't have a congenial relation anymore with my present husband. And look, kindly see at para 12, my lord. I'll just quote. What did the learned court say?
Just have your affidavit?
In my affidavit, my lord. This is, I'm just quoting, my lord.
Yes.
This says that, my lord. I'll just read the quote part, my lord. This is one of another case in which a young married lady of 31 years was burned at her residence in the presence of her husband Rohit. A beautiful lady was turned into remains of destruction caused mainly on face by the cruel hands of fire burning. She had been under treatment since then. She had been treated abroad, which can be anybody's guess that huge amount of money expenses. When the victim Meenakshi was examined in the court on 25th 10 2017, a court observation with the following words and had been made. The witness has appeared in the court with silicone sheets on major portion of her face, and same silicone sheets also available on her other body parts alleged to be treatment. She is undertaking now due to past burnt injuries, my lord. So this is the level of cruelty, my lord. Cruelty meted out against me, my lord. I had to take refuge with my father in Jaintia Hills, Star Cement.
After?
Yes.
Where's the divorce? Where's the judgment in the divorce matter?
Divorce
50, my lord. 55. Oh, sorry, my lord. 52.
Of your petition.
Of my application.
$50?
52, my lord. An extra 2.
It's before separation. Correct address, RZ 29, RZ 829 again. That's a confusion.
Well, the correct
even like
in this judgment, my lord, at page 52, this is the address provided in the suit, and this is incorrect address, my lord. The judgment also carries the incorrect address.
But what goes against you is that date of knowledge is when you applied for reduction of sentence, that divorce had already been granted.
My lord, kindly have the dates. My lord, kindly have the dates.
That's the only thing that goes. That is
Lord, kindly have the date.
2019.
Lord, kindly have that order again. That order is 19th of November 2019.
And this divorce order, so I'm looking at is 16 May 2019.
Yes, my lord.
Then
Now kindly have page 65.
1 second, let's see.
Where's the review? Review.
Alimony only 15 lakhs.
Yes, my lord. Now, my lord, page 55 is the review. It was filed, my lord. Your lordships will find the date at page 62, 28th of May 2019. Page 62 is the affidavit, dated 28th of May 2019. Thereafter, my lord, next page 62 are the.
It's filed on 28th of May.
May 2019. And my lord, the orders will be on the next page, my lord, page 62. The typed copy, your lordships will find at page 63. Now kindly have order dated 29/7/2019. It is on 29th July 2019 that notice was issued, my lord. Peruse the petition, annexures attached. Petition is hereby admitted. Issue notice to respondent. Now, my lord, kindly have the next page. Order
You
dated.
appeared when?
My lord, order dated
So you appeared when?
30th of August 2019.
You appeared.
Yes, my lord. I entered appearance. So therefore, my lord, if I entered appearance...
1 second. 30th August 2019, you
I entered appearance.
Correct. And that order of the High
It's
Court
November, my lord. It's November.
Right. Yes, Mr. Rubin.
Yes, my lord. Now, if he is saying that on 30th of August 2019 he appeared, then makes my case more easier, because that means that he already knew in the month of, so far I am submitting, that he came to know in the month of November. Now he himself is saying that I came to know in the month of August, and he appeared also in the same court. So what prevented him from challenging that the divorce order then, ex parte order then? But now he cannot escape that he did not know about the ex parte order, ex parte proceeding. Now he cannot say that.
So the review was disposed of on
2000.
Review was disposed. This is the one. Review was disposed on 18th October 2022. The last page 76.
My lord will find that in my first appeal, my lord.
Look at your first appeal.
Page 76 may see, my lord, that is review. It's a none appeared for the case in spite of order dated to dismiss the default if petitioner is not appearing, yet until petitioner did not hit warning to the court, it is seen this is pending for filing of amendment application since 03.
So the review was dismissed.
And it's dragging, yes, it was dismissed. Dismissed for non-prosecution.
His review, my lord.
Yes.
Of course.
Yes.
Where's your first appeal? I have a first appeal. This case.
Where are my applications?
Wait. When was the first appeal for? When was the first appeal for? September. September, are you? September 2023. My lord, may I give you just 3 dates, my lord? It's very clear, my lord. 3 days. Number one, my lord, I will not even go from the ex parte proceedings. I will go from the judgment and the order of the divorce, my lord. That is on 16/4/2029.
Yeah.
16/4/2021, there is a judgment and order. Now, according to his claim, in the review petition on 30th of August 2019, he appeared.
Now his review was filed
Yes.
on 28 May.
Yes.
Right.
And he appeared on 30th of August 2019.
He appeared on 30th 8
2019.
Yes, okay.
And the review petition got dismissed on 18th October 2022.
Yes.
Now, what was his first appeal? The first appeal was in the month of September 2023.
Yes.
This itself talks volume, my lord.
We will pass orders, yes.
My lord.
Just a few things, my lord. There's a miscase number 2, my lord.
In this appeal?
Not in this appeal, my lord. Before the lower court. Now, if your lordships again have the order, my entered appearance, my lord. Kindly have page 65. 38, my lord.
From your first appeal?
Yes, my lord. My lord, from the application. Now, this very same, if I may read this order, my lord. Seen the affidavit to bring on record the service of notice served upon respondent along with postal slip filed by the petitioner so-and-so, and the same is placed on CR. Learned counsel Shri so-and-so filed hazira and executed vakalatnama on behalf of respondent Shri Rohit Kalia. Also seen an application under 151 that is filed by me, my lord, for direction to the Superintendent of District Jail, Gurugram, Haryana, to allow the respondent who is undergoing sentence in the said jail to sign the required documents and affidavit in relation to the incident case. Heard so-and-so. The next paragraph, on perusal of the petition filed by the learned counsel, it appears that the respondent is undergoing sentence in relation to PS so-and-so. Upon being convicted in the incident case, the respondent wants to contest the incident case. This court is of the considered view to allow the instant application, and the Superintendent of District Jail, Gurugram, Haryana, is hereby directed to allow the respondent so-and-so to sign relevant documents. Thereafter, an application was filed, my lord.
Application where?
My lord, this would be miss case number 2, my lord. This is at page 66, annexure 7. Kindly have the order dated, type copy, my lord. Next page, order dated 26/11/2019. So, my lord, upon the order being passed by the court below, my lord, directing the jail authorities to allow me to sign the documents, I file an application, my lord. It reads, my lord, 26th November 2019, CR on call, seen Hazira filed by so-and-so. The other parties...
What kind of petition did you file?
Look, I'll just read. Seen and the perusal of the petition dated 26/11/2019. On perusal of the same, the petitioner prays before this court to issue notice to the opposite party petitioner, calling upon them to show cause as to why the ex parte judgment order so-and-so may be kept in abeyance. Also seen and peruse petition so-and-so filed by so-and-so, praying to direct the so-and-so. So, my lord, we had sought to keep that in abeyance, my lord. Keep in abeyance, and we were taking steps, my lord, to file an application for recalling. My lord, application for recalling was filed, my lord.
Where's the application?
Thereafter, my lord, page 69, the matter was...
Application for recalling?
Application for recalling, your lordships will find in my petition, in my appeal.
Which page?
My lord, the orders I have enclosed, my lord.
Which page the application?
Page 74 onwards, my lord.
The application. It's not application, it's order.
Yes, order, my lord. The record is here, my lord. I can just, my lord. So, my lord,
What is the order passed, order 9/13 application?
My lord, in between, because of the COVID period came, my lord, everything, my lord, went to cold storage.
25/10/21.
Yes, my lord. Cold. In between, my lord, when the courts had reopened, the matter was listed. Thereafter, my lord, in 2022.
Order 9/13 also is barred by time.
Lord, kindly have page.
Did you file a application for condemnation at 9/13 application before?
My lord, I'll show from the records, my lord. I'll show from the records. My lord, page 75. This is order dated 3rd of March 2022.
Yes. Page?
Page 75 and extra 8. Here, my lord, we had filed a miscase to amend the application, my lord. So, my lord, it is not that we were sleeping over our rights, my lord. We were before the lower courts, my lord.
Suppose somebody here is petition. This is the order 9/13 application.
Yes, my lord. We were seeking for amendment, my lord. The orders are not very clear, my
Suppose
lord.
somebody here a petition simultaneously. What petition with miscase 2/2021? Which petition is this with regard?
Not for recalling, my lord.
You're talking about miscase 2/21 is a recalling.
Miscase number 2 of 21 was for recalling, my lord.
Then what is the other petition that you want to hear together with your miscase?
This, my lord, was for amendment, my lord, of that particular application. Now, while pursuing all this, my lord,
See, this
in
is the
between,
one
she remarried.
Order dated 31/3.
31/3, my lord.
Where does the order end? This order dated 31/3/2022. Where's the second part of the order? This is your annexure 9 is open-ended.
Look, this is the order of the review, my lord.
That is what?
Yes.
Then where's the conclusion?
Yes, the page is missing, my lord. This is the order of the review.
How can you allow this to happen? How can a change be missing from your memo?
Actually, there's nothing doing. COVID started from 25th March.
No, forget about COVID. I'm seeing this order. Now this order passed. He's saying that this matter, see, the matter has been heard. See, see, fix on, right? 14.3 for hearing. It was heard on 28.3.
Why is this incomplete?
Where's that page? So your review stance also is gone. You can't.
Well, I do have the certified copy, and apologies, my lord.
How can it happen, Mr. Nongri? Shouldn't happen.
My lord, I can take steps to cure the defects in the first appeal, my lord. But however, today in the application, my lord, for condonation of delay,
has to overcome that first.
Yes, my lord. I have to overcome that. Then only I will get to the appeal.
That'll be a ground also. Have you made a ground in your application condonation that you have made the application that Order 9 Rule 13 is not been disposed of and is still pending? Have you made a statement? If you have not made a statement in the application for condonation, then we need to disregard everything and pass orders only, like, on the date of your knowledge and your date of when you approach the court and whether you made sufficient cause.
I'll just give that, my lord.
Whether you have any sufficient cause for the delay. That's all. Notwithstanding your internment or incarceration.
My lord, I have said, my lord, at page 5, right at the bottom, my lord, on 18th October 2022, very fairly I have said, my lord, an application under Order 7, Rule 17, or Order 6, Rule 17, and under Section 151 CPC for amendment of the cause title of the application under so-and-so was dismissed for default.
It was dismissed.
Yes,
for, then
for amendment.
That means your amendment was finished. I mean, even it was heard together with your Order 9 Rule 13 application.
My lord, my remedy for first appeal still remains, my lord. Still survives. I am explaining the delay, my lord. That I was not sleeping over my rights, my lord.
No, your main first appeal, of course. But regarding your review and Order 913, that's extinguished.
Yes,
that's all.
Yes, my lord. That is why.
It's extinguished.
That is why, my lord, I have come under first appeal, my lord.
That is why.
That is why I have come under first appeal, and I have explained my delay, my lord.
Obliged.
Deeply obliged.
Item number 5.
No, because you made a submission that Order 913, I thought it was left open-ended. That's why. But even your order annex is open-ended in the appeal memo. So what can we do?
Obliged.
Yes.
So, contempt, my lord, I was asked to implead the senior accounts officer. My lord, on the last occasion we've done that, but it seems, my lord, this particular person is not working there at the moment. So, Lordship would ask for some.
See, what has happened is that, where's Dr. Mojika?
He's on legs, Lordship.
Let him come. Call him. This needs his presence. Because some orders will be passed, they can't address letters straight to the registry.
My lord.
Item
the
number
concerned
6.
officer, whatever, who has been impleaded, he's addressed a letter to the registry.
Directly to
asking for striking of his name, yes. But that also will have to drop contempt.
Your Lordship, I grieve this matter may come up at the end of the vote as well, Your Lordship. Item 6.
Yes.
What should I say?
Item number 7.
May it please Your Lordship. Your Lordship, we have already received a copy of the affidavit filed by the respondent number 5 and 6. I'm praying for some more time to file the rejoinder affidavit.
You file affidavit?
Yes, Your Lordship.
Okay, to 5 and 6 only, rejoinder?
Your Lordship, for both, Your Lordship.
All of them?
Yes, we'll file it together for
MST
rejoinder.
and Marak please response around 2 weeks' time to file rejoinder affidavit filed by the respondents. Yes, list after 2 weeks.
Item number 8.
May I please, Your Lordship? Your Lordship, we received instruction. We need time to file our affidavit, Your Lordship. So
How much time?
2 weeks time, Your Lordship.
Your Lordship, I'm making similar prayer on behalf of Mr. K.P. Bhattacharjee.
For the 2 weeks time as prayed, allowed to respond file affidavit, yes.
Yes, Your Lordship.
Item number 9.
Then number 2, and we have already filed our affidavit.
May I please, Your Lordship?
Yes, Salam file.
Your Lordship, we're still awaiting instructions, Your Lordship. I'm on behalf of Respondent 1, Your Lordship.
I
We're still
understand.
awaiting instructions.
Not such not yet received.
No, Your
Yes,
Lordship.
affidavit on behalf of respondent number 2 and number 3 since been filed. However, MS your Guru, right?
Ki Guru.
Yes. Praise for the allowed further 2 weeks time to obtain instructions, file affidavit on behalf of the respondent number 1.
Much obliged, Lordship.
Much obliged, Lordship.
Item number 10.
May I please, Your Lordship? I'm praying for further 2 weeks time to file
Ms.
my
Mania,
rejoinder.
what happened? How many times you've taken?
This is the third time, Your Lordship.
The third time? So after this, no more opportunity.
Lordship, we're still waiting for instruction from the parties.
You won't file it anymore.
We are filing, Your Lordship. I'm praying
All
for
are file
2 weeks time
affidavits,
to
all of
file
you.
my rejoinder.
No, of course. You file. MS Iwanyang seeks last opportunity to file the joint affidavit. Last opportunity because after 3 times, no, not allowed anymore. Just after 2 weeks.
3 week times, Your Lordship, may be allowed.
2 weeks enough.
Lordship, we have to reply for 2 after.
And if you listen for hearing, then maybe you'll give an opportunity to file in the meanwhile.
11.
Yes, respondents 1 to 4, 5,
Your Lordship,
and 6 not filed.
praying for 1 week time, Your Lordship.
Or 1 to 4.
For respondent number 6.
You're 4?
Respondent.
You're 1 to 4. You are 4?
I am for 5, my lord.
You're for 6?
Yes.
What's the matter about?
Your Lordship, this matter is with regard to the issuance of NOC, non-issuance of the NOC by the headman, Your Lordship,
For
for the sale of my landed property.
For
the sale of my landed property.
Who's appearing for headman?
Lordship, respondent number 5, I appear for the headman, my lord.
Why don't you issue NOC?
My lord, I'll have to seek instruction because actually this land, particular land, my lord, it's a disputed land, my lord. It's a disputed land, and then
Where's the land situated?
it's in Riboy, my lord. It is in Riboy. What do we call it?
Nongrim.
It's beyond Boirong. It's Riboy, my lord. It's Boirong Bong. It's beyond Boirong Bong, my lord.
Okay.
So.
Okay.
So, kindly allow me a 1 week.
Why there's no? Who's the petitioner here? Yalamla. Will you file affidavit?
My lord, kindly give me a week's time. I'll file it definitely, positively, my lord. I just.
No, you won't file. What's the role of the government here? Okay. And number 5 is whom? Or you? What about?
I'm the
You're
headman.
6 or 5?
5.
I'm 5, my lord.
And 6, what is your role? Who are you? Okay, further time of 2 weeks granted to all the respondents to file the respective affidavit. Expected that the next date after should be on board.
My lord. My lord. Obliged.
Item number 12.
Lordship, the affidavits are awaited from the respondents.
I appear for 1, 2. Respondent 1 and 2, madam.
3, you're not filing affidavit.
Lordship, in my case, my client is going through the knee surgery, Lordship. So it's
Going
very,
through?
The respondent here, number 3, is going through a knee surgery. It's a total knee replacement. So, Lordship, I'm unable to get all the instructions, Lordship. He's still going under the treatment.
Who are you, number 3?
Number 3,
He's the objector to the land compensation.
Why he can't get instructions? He's a very learned person. He doesn't need to sign with his knee, he can sign with his hand.
Lordship, because I'm not getting all the documents from him, Lordship. That is why I'm unable to file. Whatever I'm getting is only.
We can't impute personal knowledge, but in this case, you file your affidavit, yes.
I'll be filing, Lordship.
Your objector, do you have any locus to object?
As per the instruction.
Who are you in the proceedings? Regarding fencing.
Land compensation, fence, border fencing.
Not able to furnish any documents to us, my lord, to his claim. So far, my lord.
Objection is only one page, Lordship. He's
So
claiming
what
to
he's
be the
saying
custodian.
is that he has the papers and he has the claim. So I am unable, Lordship, to place it because.
Then we will go around with affidavit. Then we will.
Lordship, I'll file at the moment.
No need for affidavit. We'll ask for the records, whatever is necessary, and no need affidavit not necessary. You don't have any documents. Did you produce the documents for the deputy commissioner?
No, my
No,
lord.
Lord.
He has not been able to produce anything. In fact, my lord, we have already given him intimation to produce necessary documents of his claim, my lord. He has not submitted.
Objection is at page 69, Lordship.
We can't have these kind of things like, a busy body is coming in the middle. It's not this only case. There's some cases in Shella also where real people have been deprived of agricultural land, and because of some busy body from Shillong who goes and just files some objection, and the deputy commissioners are too scared to do anything also, they just stop the whole compensation. And the result is that cultivations lost, compensation is not got. And these people are not able to show even one shred of document to establish their claim, and they keep on, the matter lingers, person dies without getting compensation.
In this case, Your Lordship, by this, the DC has taken 69, Lordship.
Landlord of what?
Show me
Oh, he's claiming from belongs to my family descendant from the maternal clan of Jayanta Rajas, being the same Sudganga clan, now from an area of 8 villages who have been given permission by me since the years 1990 onwards. So his claim is from 1800s from those Rajas.
Yes,
How is he connected to this thing? At least you give that line. At least you give that lineal descent. And how is he holding the, is he holding the what?
the claim that he's.
No, how is he holding the authority of this line that's gone of this Jayanta Rajas? Who is he?
I'll definitely try, Lordship, and if
he's just AM descent, we can understand, but he's a Jayanta Raja. You take down. Yes. Affidavit. You haven't filed affidavit also.
No, my lord, we have not filed it.
Affidavits are still awaited from the respondents number.
All respondents.
All the respondents. Stop. MSS. You get a SK in the room.
Yes, Lordship.
Appearing for the respondent number 3 has submitted that the affidavit on behalf of the respondent can be filed in view of the fact that the person is undergoing medical treatment. Stop. Next paragraph. Mr. Emalong, on behalf of the petitioner, has raised certain objections to the prayer for extension of time and has submitted that the objector, even before the deputy commissioner,
My lord, we have given him intimation on 20.
has come with has come with a bold objection dated 27 September 22 with regard to the payment of compensation. Stop. MSR Koni, on behalf of the respondents,
1 and 2.
1 and 2 has also submitted that the set respondent number 3 was directed to provide
To furnish supporting
to
documents.
furnish supporting documents in support of objection, which, however, have not been forthcoming
Since 2022, my lord.
since 2022. Stop. This court observes that is constrained to observe that in such matters where bold allegations have been made, compensation which is due to rightful parties is being held up, as is happening in instant case. In this matter, MSSK Nongrong directed to obtain instructions positively within 2 weeks, feeling which the matter will be decided on the materials available on record. You can't allow this.
Yes,
It's
sir.
happened too many times.
We have been taking time.
Yes.
Obliged, Lordship.
Please, Lordship. Lordship, I'll be filing my affidavit in the course of the day. And for respondent number 6.
We have been paid,
No, Your Lordship, I've been allowed to discharge my duties.
but
I've been allowed to discharge my duties, Lordship.
what about the other? Who are the number 5?
Lordship, I'm appearing on behalf of respondent number 4, Lordship.
Who are you? You're allowed to work now. Number 6?
I'm there, Malad, the church.
Who are you?
The church, Malad.
5,
Balak
6,
School.
4. Who are you?
School managing committee, Lordship.
None of you file affidavit as yet.
Lordship, I'm praying for
Why?
2 more weeks' time, Lordship.
I'm filing in the course of the day, Malad, for number 6.
The counsel for all the respondents pray that they be allowed some more time to file affidavit stuff. Accordingly, 2 weeks for them to grant it. List this matter and so and so. Interim orders will continue next date.
Obliged, Lordship.
14.
This can be disposed of, madam.
There's no petitioner.
My lord.
Oh, Mr. Kumar, what's
I for the petitioner, my lord.
Yes.
My lord, here they are asking for pursuant to Lordship's direction, my lord, their upgradation to the rank of warrant officer, my lord, has been treated as upgradation, not as a promotion now, my lord. So as a consequence to that, they are entitled now to ACP and MSCP, my lord. Next page, my lord, so page that will reveal, my lord.
This is 61. Yes.
24th April 24.
Yes.
So my lord, all the petitions are there under consideration, my lord. And that we are only praying for 3 months' time. Within that period, it will be done, my lord. Because there are about 1,500 such petitions, my lord.
So because it was not treated as a promotion, and they are in cipher only.
My lord.
Then why
Yes, my lord, they are cipher.
Then why discriminated?
No, my lord. Earlier, we treated their upgradation as promotion, my lord.
Yes, now that's gone. After
Then
the
orders have
order,
been
then
passed by Lordship and also Guwahati High Court. So now we have treated that as upgradation, my lord, not as a promotion. So as a consequence to that, my lord, they will be entitled to ACP and MSCP, my lord.
Right, take down at the outset itself, the learned DSGI Dr. N. Mozika has informed the court that the grievances of the petitioners has since been redressed. In this connection, the learned senior counsel has placed before the court. What is this called?
Board of Officers to consider their.
No, what is communication called? Has placed before this court a communication.
Communication.
Dated 24th April.
My lord.
2024, wherein the board of it is indicated that
Board of Officers for screening of ciphers.
For screening of ciphers.
Category personnel.
Category personnel for grant of ACP, capital ACP, and MACP as per the entitlement has already been convened. And as the numbers, as the numbers are over 300, you said?
1,050 numbers.
1,050 people. As the numbers of the person under consideration will number of 1,000. 3 months, minimum of 3 months time will be required to grant the said benefits. Correct?
Well,
yes, sir. Therefore,
in fact, 4 months. They're asking for 4 months.
In view of this, development, the representation will be closed, allowing the respondents 4 months to complete the process. Stop. Next para, Mr. V. Kumar, Council Petitioner, no objection. 4 months, give them 4 months. Yes,
My lord.
no objection to the said submissions. Next para, heard the counsel for the parties. Stop. In view of submissions made by the JSGI, this writ petition is being disposed of at this stage. Placing reliance on the communication dated 24th April 2024, which is reproduced here and below. Stop. Next panel. Accordingly, the matter stands closed and disposed of, and as prayed, the respondents are granted 4 months' time to complete the process as to the entitlement of the writ petitioners. Copy of the
My lord.
communication is also taken on board and made part of the record. Yes.
Deeply.
My lord. Deeply, your lordship.
Yes.
15. 15.
May I please, Your Lordship, I have received the para-wise comment.
Yes?
I have received the para-wise comment, Your Lordship.
What does it say?
Yes.
It can be disposed of for affidavit?
No, not Your
Why?
Lordship. Because draft also prepared, but it will be sent today, Your Lordship. So I need 2 weeks time, Your Lordship.
Compassionate ground appointment?
Compassionate because
Yes, as paid for the 2 weeks time, granted the response file affidavit list thereafter and so on.
much obliged.
16.
18 days. Please, Your Lordship, this is that case where the candidate was disqualified on the ground of a general issue. They were to get instructions.
Yes, with bad teeth, you can disqualify a candidate. Dr. Mosika, it would take instructions.
I'm still awaiting instructions. I'll kindly grant me 1 week's time. I'll have instructions.
Dr. Mosika submits that note she had been.
Please, Your Lordship, this is the 3rd time they are seeking
Yes.
instructions.
And it's just on the ground of, you see, only on teeth, bad teeth he has.
Yes. Yes, that's the only ground.
I'll just pursue it.
Is it written anywhere that with bad teeth you can't be considered eligible?
I might have to bite bullets or something.
Please, Lordship, the only ground on which a person can be held disqualified on the ground of teeth can be where he has less than 14 dental points. Now, this is not that case.
He has more than 14 dental points.
There's more than 14. He has been disqualified because his teeth are not aligned properly. So that is not a ground under the medical guidelines.
The medical guidelines say that, then why?
And I have annexed the medical guidelines with my petition.
I'll file affidavit.
Within 1 week, within one
a
week,
week.
yes. Last opportunity to obtain instructions granted to the respondents just after 1 week. So it is endeavor shall be disposed of the matter on the next date. As you come with the law. If it's 14 dental points, less than 14
Please,
teeth,
Lordship,
that's
that I
allowed
have
25.
annexed with my petition also, the medical
This is
guidelines.
something
I have-
unusual. I'll just find out.
Yes.
Yes. Yes.
Your Lordship, in this matter, if no affidavit is forthcoming from the respondent, I'm praying that this matter may be listed for hearing.
No?
If the respondent are not filing any affidavit, I'm praying that
You're
this
not filing?
We are not filing, but I don't know about Mr. Paul.
No, Mr. Paul has filed caveat. You won't file affidavit? Is there urgency? Five, who is 5?
Chief of Bhawal, same ship.
Which stock of, okay. Yes, Mr. Chanda praised that he will not over 2 weeks for it and to file affidavit on behalf of spot number 6. Praised always up to 2 weeks.
I'll do that.
18.
He also I'm praying for some more time.
I
First
filed
time
my
appearing.
service of affidavit.
Yes, Mr. S. Chanda has an appearance on behalf of number 5 today. As such, notice is complete on all the respondents.
Respondent number 5 is now in West Bengal, Lordship. So sometime we
Your second wife? Or first wife?
No, my lord, petitioner is the father, my lord.
No, who are you? Who's Pratiksha Pradhan?
Daughter-in-law of the petitioner.
Of the petitioner? It's for pension?
The father and the wife, there is a dispute.
Father?
Dispute is between the petitioner
Father
and
of the deceased employee, my lord, and the wife. Wife is, it seems that she deserted and she remarried somewhere in Darjeeling, my lord. So father is claiming, he's an old man.
So don't use as a ground to file an affidavit after 6 months. Within 2 weeks.
She's serving in West Bengal Police now. She's in requisition for election purposes. That's the only reason also.
Okay. Yes, Mr. S. Chanda prays for, has an appearance on behalf of Respondent 5 today. He submits that as the Respondent 5 serving West Bengal Police, he may be given 4 weeks' time to file affidavit. Accordingly, list after 4 weeks.
Much obliged.
Item 19.
For affidavit by the respondents, yes. Yes, instructions.
Yes, Your Lordship. Your Lordship, we've received instructions, and Your Lordship, as per our instructions, the constitution of the VMC, Your Lordship, is just a temporary measure because
Of the?
VMC, Your
What
Lordship,
VMC?
the Village Monitoring Committee.
VMC, okay.
Yes, Your Lordship. Your Lordship, here the Secretary of the VEC had made a request to constitute the VMC in order to ensure smooth functioning of all the works, Your Lordship, because there are 10 works that are being executed concurrently, and the Secretary, the VEC, cannot monitor all the works at the same time. So the VMCs have been constituted as a temporary measure only, Your Lordship, to ensure that all the works are executed properly.
Yes.
So, Your Lordship, if I may place these instructions by way of an affidavit, Your Lordship.
Yes, instructions, MS in Hungary appearing for the state respondents.
1 to 4, Your
submitted that the VMCs which have been called in question were constituted to ensure the smooth implementation of projects under the Mola Kandi VEC. She prays without to bring the set instructions by affidavit. Then we'll issue notice for respondents then, since you are challenging the elections also, correct?
Yes, Your Lordship.
Yes, in this view, the matter, not this matter, the learned GA is allowed to, as per it is allowed to file the,
Affidavit in opposition, Your Lordship.
bringing on record the set instructions. Stop next paragraph. Notice also to issue to the right respondents number 5 to
37.
5 to
37, Your Lordship.
37.
Yes, Your Lordship.
Within a period of 3 days, but I said ADS. List after 3 weeks for affidavit for service report on the right respondents. Yes.
Obliged, Your Lordship.
Item number 20.
May it please Your Lordship.
Yes, what happened?
Lordship, we have received instructions.
Why are you
Your
not allowed
Lordship.
to join?
Lordship, I can show precisely. Which one? This one. Lordship, from the instructions we have received, Lordship, they are attempting to accommodate the petitioner, Lordship, in a post concerning his present situation, and also that there's also a prayer that some time may be given for that, Lordship. But at the end of the day,
what about
Lordship,
the
salary will be paid from 1st of September, with effect from 1st of September 23, Lordship.
When? Tomorrow?
Lordship, if a time frame may be given, Lordship, but not tomorrow.
Sure instructions?
Lordship.
We'll dispose of this matter, Mr. Kinsey. No sense in keeping these.
Is that paragraph 15, Lordship?
Yes. It makes no sense if a post is yet to be filled by selection, and a person's posted at a post that, that they said, ask them to withdraw the selection. Instructions have been received by the senior government advocate and the same appeals for this court. Stop. It is noted from set instructions that that the non-accommodation of the petitioner to the transferred post was in view of the fact that the said post had been advertised by the District Selection Committee.
DSC East Khasi Hills or
Yes,
West Khasi
District
Hills.
Selection Committee, West Khasi Hills District. Stop. The said situation is indeed strange in view of the fact that the writ petitioner is a regular employee who was sent a routine transfer. Stop. As such, the reason offered by the respondents is totally misplaced. Stop. And in this view of the matter, new instructions are received, the respondents are directed to allow the writ petitioner.
In this case, my lord, I have filed a miscase, my lord.
To allow him to continue in July.
Yes, my lord. In July,
No, I'll not say anything. That miscase will not consider because posting and transfer, that is up to the respondents. Only thing is that if you're a regular employee, you're not getting salary, and you'll be allowed to be posted at some place. That's all. No? Allow the petitioner to continue to serve in the post of Forester 1.
Lordship.
Yes, and be accommodated in where there's a suitable vacancy. Stop. It's further directed that every salaries as due should be paid within a period of 2 weeks from the date of this order today. Stop. The writ petition on directions as above stands disposed of. Thank you.
Much obliged, Lordship.
Let them accommodate anyway. This
Lordship.
Absolute strange. We can't ask them to withdraw. So if there's a vacancy for a district, if it's a non-responsible post, we can't withdraw the nomination also. That's how a person get employment. And with the post vacant there, it's seeking anyway.
Second
Correct
call.
order, yes.
Second
My
call,
lordship.
item 5.
Yes, Mr. Dr. Mozika, you see,
He wrote directly my lord, to the registrar. My lord.
Yes. Why have you done this? Who's this person?
They don't even take legal advice, my lord. My lord, let him come appear before your lordship, my lord.
Where's the petitioner gone?
This matter started in 2018.
No, we're not bothering about this letter.
He's writing directly to the registrar.
Just keep.
Yes. Office note, I make note about this letter. Em come talk. And police hang me come talk. Come talk please for the court, play.
Who wrote this letter?
Yeah, come.
No name also.
Mehta. Philip Mehta. But no, please, can you please? It was implemented by which order? Dated?
3rd April, 3/4/24.
Take down, no? You seen the letter, Dr. Majika?
I have a copy.
How do you get the copy?
Who gave the copy? From their office, my lord. From the department, I got some reference.
A letter has been placed before the court dated 12/4/2024, wherein the senior accounts officer pay an accounts officer bracket AR capital, then next line same line MHA, the Home Affairs, comma, Government of India, comma, Shillong 11, comma, Apuli. Has written to the Joint Registrar for substituting the respondent number 2 to senior SR AO, capital A, capital O, comma, family pension instead of senior AO, administration ADMN, section. Stop. This court fails to understand, next paragraph, as to under what procedure and in what manner such a letter has been addressed seeking substitution in name. Stop. Substitution in names. If any request is to be made, the same should have been done through the duly appointed counsel representing the respondents, and not the manner as done by the author of this letter. Stop. Forget making him appear, no point, just delay the matter. It is made clear that any instructions, though the matter is serious and a serious breach of procedure, the said officer is let off with a warning at this stage. Stop. As observed earlier, any such instructions or requests should be to the duly appointed counsel. This is a matter after 2 weeks. Yes.
Item number 6.
Instruction last time. In 6, on last occasion, I placed instruction, but the matter can be disposed of subject to what?
Yes.
Yes, my lord, this matter can be disposed of since now the department has admitted that there was a mistake on their part. It was the duty which was already paid by them was not taken into consideration. Accordingly, my lord, they rectified, and then they assessed that a sum of rupees 3 lakh something is to be paid, to be recovered from the party, which the party is going to deposit, or they can adjust from any other bill. So far as this case is concerned, it can be disposed of. The restriction can be allowed by setting aside and quashing the impugn orders, my lord. Otherwise, if the impugn order remains, it may again create confusion in future.
No quashing is required, my lord. That can be recorded and the matter can be disposed of. Nothing survives now.
Quashing is required, my lord, because that was a wrong order issued by them. That's
If you
my
want
final bill is.
quashing, then you'll have to come personally.
In that case, my lord, let it be fixed on another date next week. I'll be there, my lord.
First. That's just in jest. Yes.
Well, the Annexure 10 at page 25, by which they have wrongly assessed that my final bill stands at minus 56 lakh something. Now they have admitted that they did not consider the VAT which I have already paid, deposited, which was not considered, and accordingly they assessed it wrongly.
Where is that?
And they have
impute order?
corrected.
Yes, yes, Mr.
But the instructions are placed, madam.
So where's the?
So
Yeah, it's clear. Where's the petition? There's a petition. Oh, yes. What page is impugn order?
Next 10, Your Lordship.
Annexure 10, page 25.
Page
Letter
20,
dated 16 November 2022.
Okay.
And we also, and pursuant to that, my lord, later Annexure 12 was issued, directing all garrison engineers everywhere
After recovering
to
amount
not to release.
Will become minus and final bill minus and what's the 56 lakh deposit given in 25?
But earlier we were supposed to recover 56 lakh from them, my lord.
Yes.
So then they came before the Honorable Court saying that GST has not been adjusted, they are not liable to pay that much. So now, after the case was filed, we've revised it. Now they are liable to pay only 3 lakh something, my lord, which they are agreeing to pay. So this calculation has been revised, my lord. So in my humble submission,
So where do you see from a communication is?
30th March letter, my lord.
Yeah, 30th March. First is 30th March, second 30th March also.
Well, there it has been, the amount has been recalculated as 3 lakh rupees, my lord. So we'll see that.
Where's the audited bill? Is that here?
Well, no.
That they have given in their affidavit, my lord. In their affidavit, they have stated that it is 3 lakh something is now due, which we do not dispute, my lord.
So you have to give them money.
Now 3 lakh only they have to give.
They have to pay you instead of you getting the money.
Only 3 lakh. That they can adjust from our other bills, or we will pay by cash to the department.
Yes, take down.
My lord, only thing why I'm praying, my lord, because he is having worked with different garrison engineers. If this letter was circulated to everyone, so if this is not quashed, again it may create problem with other GEs also. That is why, my lord.
Where's letter date 19? Where's letter dated 1922? Now he's saying you 3 letters impugning.
22.
One is 16/11/22. One is 15/3/23. Where's first one?
These two are the main ones, my lord.
16/11/22. Just now 25, correct?
Annexure 10, Annexure 12.
Okay. Annexure. Then what is 1922? What's 1922?
1922, Your Lordship, is a communication we made.
Where is that?
Next
Page 30.
11, you know.
Page 30.
Page 30. This is date. Where's the date?
It's in a box on the right hand side, the 101092.
Oh yes. This is from whom?
Controller of Defense Accounts.
This is from two. This is garrison engineer.
The issued by CDA, my lord, addressed to garrison engineer.
And what is 15/3/23? You want to know what's in the prayer? What's 15/3/23?
This is page 30. They have to number it twice, my lord. Maybe page 31 or 32, my lord. Lordship says. Annexure 12.
This is outstanding recovery from contractor. There's no date also. Oh, 15 March 23. Okay. Okay. Yes, sir. The petitioner. cases before this court for re-verification of the amounts for the verification of the final bill, where there it indicated there where it was shown there has been deduction of VAT and labour cess.
It's a minus bill, my lord.
So, the minus bill.
Minus bill of rupees 56 lakh.
Collected minus final bill, where it has been shown that there is a deduction of VAT and labour cess. Stop. It had been submitted that the price quoted by the petitioner was already inclusive of VAT and other taxes, but in the final bill, the VAT percentage was wrongly added on the price quoted, and as such, they have prayed that, and as such, where's that bill where they've shown 56 lakhs instead of 25? And as such, the amount recoverable shown, where's that, Mr. Wanswet? Or 25 years. And instead, it has been shown that the final bill passed on minus side required the petitioner to deposit a sum of rupees 56 lakhs,
56 lakhs
005, 861 in favor of the respondent garrison engineer. Stop. Today, when the matter is taken up, Mr. Dr. N. Mozika, on instructions, has produced a communication from the garrison engineer, dated 30th March 2024, wherein it is recorded that it says, please hold copy of the bill bearing so and so and so, wherein it is indicated on a re-examination. No, it's not indicated. Which shows that, in fact, the minus final bill amount is only of rupees 3,31,916, which is payable by the petitioner. Stop. Next para. In view of this development, the parties pray that the matter, that incident petition, be closed. Stop. Considering submissions and having examined the letter dated 2024, it appears that nothing remains for consideration in the incident petition, as the writ petitioner also is agreeable to to pay the final amount bill of rupees 3,31,916. Stop. Accordingly, in view of the matter.
My lord, one more thing.
Yes.
There is.
Yes.
We are also entitled. The contractors are entitled for reimbursement of the labor cess which is deducted from their bills, as per the agreement.
Yeah, you agree.
And they have admitted in their affidavit that can be. They have agreed in their affidavit.
See, you're derailing the order now.
See,
please, you're derailing the order now. I'm passing order in your favor, and you're derailing my thought process. Thought, no? Subject to other claims that you might have with regard to the contracts. So, accordingly, the writ petition is disposed of, and the impugned letter dated, what is that?
Page 25.
Dated 16 November 2022. Stop. Where the said demand has been made. The demand notice, no? You can see where the
Yes.
is set aside and quashed.
16 November 22, Annexure 10.
Yes. But matter of sense close dispose of it. Copy of the letter 30 March 2024 is taken on board, made part of the record. Yes.
Hearing item 21.
Obliged, Your Lordship.
Yes.
This is a partner matter. Last week we made submission, but they were appointed after interview and with due approval of the cabinet. And even after 14 years, there was no DSC or public service interview. So we prayed for regularization. So in this case, my lord, I am citing one is Supreme Court. Last week only it came that in this such type of circumstances, my lord, the entry of the petitioners cannot be said to be illegal. At best, it can be said to be irregular because there was no DSC interview till date. So in such a situation, my lord, the Supreme Court has said that it can be.
No, I wanted you one authority from you that they should have a special recruitment, whether it's permissible or not. Correct?
Yes.
Yes, you got authority on
No,
that.
my lord, on this part, the Supreme Court is saying that there is no bar for regularization.
No bar, but then whether they, they can have a special recruitment only for your petitioners. That's all. There are some judgments, I think. I've not had the time to examine. Now I remember this matter. That after hearing, we said that since it's not their fault that they've been deprived of, of regular appointment.
Yes.
Whenever the matter had been advertised, they were ready to go. The absence of abeyance. How many times it happened?
3 times.
3 times.
And 3 times director wrote to the authorities that please.
3 times. Their request for regularization had been rejected also.
Rejected, of course, because they didn't come through. They haven't come to DSC. They came to departmental selection committee. But notwithstanding, there was a selection process. Number 1. Number 2, but through no fault of theirs, they've been deprived of regular appointment. So whether the only thing is that now you hold special recruitment for them.
Can you see, Your Lordship? They are the petitioner. They are bound by the term and condition contained in the advertisement, Your Lordship.
Bound, yes.
The advertisement is very clear, Your Lordship.
We are not going to advertisement now, Mr. Shulai.
Lordship.
We are going by special recruitment. If they are fit, you retain them. If they are unfit, you discard them. Finish.
Lordship.
Then you give the judgment.
3 judgment I'm giving for that. There is no bar for regularization.
Let's see that. There's no bar. There can be no bar. But the thing is that let there be a. You see, this appointment has to be regularized through a proper selection process.
Yes.
Correct.
Yes.
So in your case, you've been deprived of coming forward for regular selection because of the actions of
the director.
The director only. Every time after it's been floated, you're ready to go, it's been kept in abeyance. Second time, after it's been floated again, you're ready to go, kept in abeyance. Third time again, every time after every file representation, they reject your request. So where does it leave
3 times, Your Lordship. 2015, 18, and 23, Your Lordship. Rejected.
See, 15 rejected.
Then
that
2018, Your Lordship.
Then 17 again, then it's kept in abeyance. Then 18 again, they ask for realization. Request again 20.
Rejected in
then again in
2023.
20, they kept the advertisement in abeyance. How many times? Then 22 again, they ask for my little note. Yes. How many times will you keep them waiting? What does this judgment say?
Paragraph 8 says, last page, man, paragraph 8.
8.
Yes.
Vikramnath.
In the light of the reasons recorded above, the court finds merit in the appellant's argument and holds that their service conditions as evolved over time warrant a reclassification from temporary to regular status. The failure to recognize the substantive nature of the role and the
What is the subject matter? The facts are similar.
is almost similar, madam. They were appointed as accountant and they remained in service almost for 25 years, my lord. Therefore, the Supreme Court said that they should be regularized.
Either Mr. Shulai, look at it and you bring the decision regarding special recruitment. You have brought it here.
No, Your Lordship.
You kindly get that, then we dispose it of.
Lordship,
Court
yes.
only
I'll
on
do
the next
that,
day.
Your Lordship. I'll do
Next
that.
week, yes. I'll look at the judgment also you produce.
Lordship, yes.
Otherwise,
We'll also do.
yes, so just after 1 week, we'll dispose it of in court only.
Lordship.
You just bring the authority
Lordship.
regarding special recruitment.
Lordship.
To enable the court, enable the parties to furnish more authorities. This is a matter of 1 week.
Till 31, Your Lordship.
Item
21 to 31, Your Lordship. Yes,
21 to 31.
Lordship, yes.
34.
Problem.
34 to 1. Huh? 34 to 1.
This is that matter.
You already heard this one also. Already heard.
My Lord has heard it, my Lord. My Lord, the short issue involved in this matter is whether notification can override a statutory provision. Now, my Lord, what has happened is after the fifth pay commission, the recommendations of the fifth pay commission was notified by the state, and it received the assent of the government. Then the government of Meghalaya came up with the Meghalaya Service Revision of Pay Rules, 2018. The Meghalaya Service Pay Revision of Pay Rules extend to work charge employees also. Now, accordingly...
Why did the hearing stop last time?
My Lord, my friend was supposed to produce some office
My Lord, during the
noting.
course of the hearing, my Lord, a reference was drawn to a certain letter from the government, my Lord.
You got it?
Yes.
What does it say?
So, my Lord,
Local
here
decision-making process as to why they arrived at that little...
Yes, my Lord.
Thing that
The advice, my Lord, the advice was sought by the concerned PWD department from the finance, my Lord. And then the finance department came to a finding that, no, they are not entitled, my Lord.
Why?
Because, my Lord, they cannot be regarded as work charge employees because they are appointed post 1997, my Lord, when the post has been held to be no longer permissible, my Lord. So this is the finance noting.
You just give them a copy also. Let us see.
Because the post was declared banned, my Lord.
Is there which you already is on?
My Lord, kindly takes a look at the last page, my Lord. This is the noting from the finance department, my Lord. My Lord, this is the noting where it says, my Lord, Public Works, R&D Department. As per rules, Office Memorandum on the implementation of the 5th Meghalaya Pay Commission, the revised pay is applicable to the work charge personnel who are appointed prior to 27/10/1997. Further, since the appointment to work charge personnel has been banned from 27/10/1997, the question of admissibility...
Let me read this other letter first, reminder. Then you know, now they're getting from 6 pay commission.
My Lord, they got it, and then it was stopped from the month of August.
Of?
August of... August of 2021.
In my matter, my Lord, I am continuing under the directions of this.
There is a stay in some of these matters.
Stay in recovery or stay in?
But to continue the payment. When they stopped, I immediately approached this.
there's nothing new, Mr. KP.
My lord, what had happened, my lord, on the last occasion when the matter was taken up, my lord? My lord, there was a query from this honorable court, my lord, that what is the process through which this decision is taken, my lord. So the process is...
This is making process, because as per your, where is that?
My lord, if I refer to the affidavit, my lord, if I refer to the affidavit which is filed in WPC 403 of 2021, my lord, starting from...
Well, 10 June, this letter. Okay. Yes.
My lord, in the last annexure, which is page 48 of the affidavit, my lord, which is filed in the first case, the leading case, my lord, 403 of 2021. 403 of 2021, my lord. In last page.
Yeah, this is the letter in the red petition. By this letter it was stopped.
My lord, dated 23rd March 2020, my lord. Now there is a reference to letter number below, my lord, will kindly see. Reference to letter number dated 29/11/2019. So, my lord, this was not part of the record. Thereafter, my lord, this is at page 48, my lord.
So this is the letter 2011-2019. This is letter now.
This is the letter now.
It's just a forwarding letter.
Yes, my lord. What had happened, my lord?
No,
if I'm allowed to
forward the 10/6/19. My lord, 10/6/19. Getting confusing.
My lord, 10/6/19 is the subsequent letter, my lord. Below, if my lord takes a look at the next page, my lord.
Letter asking for clarification. Yes. Then?
My lord, if I'm kindly allowed to read, my lord, page 48, letter dated 23rd March 2020, my lord, what it says.
Right.
So, my lord, the subject matter. What is the subject matter, my lord, will kindly see. The subject matter is eligibility of work charge employees appointed after 27/10/1997 to the 5th Meghalaya Pay Commission recommendation. My lord, this was the query from the department. What is the eligibility of those incumbents or the candidates who are appointed subsequent, that is post 1997, my lord. So in this letter, there was a reference also to this letter, my lord, dated 29/11/2019. Now, this letter was not a part of this affidavit in opposition which was filed. Therefore, my lord, there was a query from this honorable court that where is this letter?
Yes.
So this is the letter, my lord, which is before my lord.
This is a forwarding letter. Enclosing another letter is 10/6/19. 10/6/19 is the same another query from the previous.
My lord, now following that, my lord, is the noting from the finance department, my lord, where it stated that
letter also says the same thing, that since
where it says that my lord, that they are not eligible for the 5th pay commission, my lord, because the Meghalaya Pay Commission, the revised pay is applicable to work charge personnel who are appointed prior to 27/10/1997. This is the clarification which is issued by the finance department, my lord.
So that's the only stand.
My lord, another stand, my lord, is that the decision of the finance department is final. But before I go into that, my lord, if I am allowed to read the same annexure, my lord, page 48 of our affidavit in opposition, which is filed in WPC number 403, 2021.
Yes.
With reference to your letter on the subject cited above, I am directed to say that the Government in Finance PR Department have stated that as per rules /office memorandum on the implementation of the 5th pay commission, the revised pay is applicable to the work charge personnel who were appointed prior to 27/10/1997. So, my lord, this reference is drawn from this office noting, my lord. There was a query on the last occasion, my lord, that where did you draw this conclusion? So this noting is squarely based on the, my lord, noting issued by the finance department, my lord. Further, since appointment to work charge personnel has been banned from 27/10/1997, the question of admissibility of the revised pay does not arise. The issues with the approval of finance PR department, wide ID number so and so, dated 19/3/2020. So, my lord, 19/3/2020 my lord will kindly see, this is the one, my lord. This is the noting, file noting. On the last occasion, my lord, I had stated that it is based on the noting of the file noting of the finance department. Deputy Secretary, Finance Pay Revision Department.
Now, with the memorandum,
my lord,
in
what the rule says, my lord, if I
Yes,
if
with
I
the
draw
rule.
my lord's attention to the rules, my lord, which is at page 46, the relevant portion is at page 46.
in your affidavit.
Yes, my lord. This at rule 15, my lord, serial number 15, interpretation.
Okay.
If any question arises relating to the interpretation of any of the provisions of these rules, it shall be referred to the Government of Meghalaya in Finance Pay Revision Department for decision. So, my lord, the decision of the Finance Department is final. Now, this will obviously this will amount, in my respectful submission, this will very much amount to interpretation, my lord, because rule says work charge. Now, what is the meaning of work charge?
That's a new angle.
My lord,
Amounts to
so
interpretation.
who will decide that who is a work charge and who is not a work charge, my lord? So, the Finance Department has given a clear finding, my lord. Those are appointed prior to 1997, they are regarded as work charge. So, this 5th Pay Commission benefit will be applicable to them, my lord. But for those people who are appointed post 1997, my lord, those benefits will not be available
to them.
Yes. Even assuming certain benefit is given to them, my lord, government has the right to take it away.
Lord, this issue still remains. Can an office memorandum or an office noting or a departmental noting override a statutory provision under Article 309? Well, the rules very clearly say the rules do not make any classification of work charge employees.
My lord, that is exactly.
Please let me submit.
That is exactly why this interpretation is required, my lord.
Relax, relax.
And the question of interpretation, my lord, my respectful submission comes only when there is ambiguity. Where is the ambiguity here?
The last 2018, correct?
Yes.
Which rule is that?
My lord, this is the revision of pay rules, no?
This is, my lord, rule I am referring to.
Revision of pay rules 2018.
18 years.
Yes, 2018, my lord. It starts from page 35 onwards, my lord.
No, there's a lot. This is the latest one.
Yes, ma'am.
This is the latest one, my lord.
What is prevalent today in the state of Meghalaya is the 5th Pay Commission recommendation.
Page 35 onwards of our affidavit, my lord.
No, no. Which rule is that?
My lord, rule 15. I've stated rule 15, my lord. The notification is dated 1st March 2018, my lord. FR number issued by wide FR number 77/2017/117, dated 1st March 2018.
Oh, that's the only question, I think, with regard to whether the memorandum can override the rules. Yes.
But first, the petitioners will have to establish their right. What is their right? What is their legal right? Where is the legal right? My lord, where is the legal right to claim pay parity? Plus, please show us your right.
Rule 2 clearly provides, my lord, the categories of government employees to whom the rules shall apply. That is the pay revision rule. It says that save as otherwise provided by or under this rules, these rules shall apply to person appointed in civil services and post in connection with the affairs of the state of Meghalaya, including persons in work charge establishment. So clearly it includes...
No, what he's arguing is this, that even if this rule says that interpretation of these rules, as per again Rule 15 of these rules, is that it enables them that flexibility to classify. Now, but you're admittedly upon his work charge.
Yes, we are
so unless they amend the rules,
they have to amend the rule. The only way is that they have to amend the rules.
the work charge, as it says work charge, it includes everyone. Now, interpretation, you say interpretation.
No, my lord.
Question interpretation has come on 15, and Finance Department is the final authority to interpret the rules.
Yes, my
and
lord.
so they have interpreted that 97 or 97 not permissible.
Yes, my lord.
That's it, right?
And my lord, all the while the state has canvassed this case that since 27th October 1997, work charge employment is banned. Now, if my lord will come to their affidavit at page 8, nowhere does this letter say that it is banned. It only says that no department shall henceforth make any appointment under the head work charge employee. It only says that. It is a kind of a direction, my lord. Now, my lord, they have adopted their own guidelines, my lord.
My lord, what would be the outcome of that direction, my lord?
Outcome direction is
they
that
don't follow their own directions. My lord, how can they come and say this now? How can they come and take this plea now? That means if all people, all employees appointed under...
My lord, whether they are regular employees or not, whether they can claim the benefit of a regular employee.
where authorities he brought.
My lord, I have some authorities, my lord.
What are the authorities?
I have one more authority, my lord, but
Yes.
unfortunately I
Let
do
us
not
see,
have.
very interesting, this one. Whether by the action of the state in appointing work charge establishment and called by the rules, whether subsequent by memorandum that whatever benefits they have been given can be taken away.
My lord,
And whether the act is justifiable.
My lord, so far as...
My lord, I would like to play some more, my lord, but for that I pray for another date, my
Before
lord.
that, your lordships recollect you, I also placed the fifth pay commission report, whereby it has been recorded that in PWD department there are 717 work charge employees.
Of which you are part of them.
Yes, Lord. And therefore they are also entitled. And work charge employees are appointed under, my lord, the financial rules, Meghalaya financial rules of 1981.
Is that there in the repetition?
My lord,
No.
I have handed over, my lord, last time the copy of the report.
My lord,
to understand the object of the rules.
My lord, the pay commission recommendation, my lord, respectfully submit, my lord, is only a recommendation, my lord.
It's been accepted. It's accepted. So what the recommendations there. If you accept parts of it, you can also just take certain parts which is suitable and see these recommendations are accepted. I know we discard the others, but the thing is that it is inspected in part and everything is in
As far as
total.
the, my lord, as
Number
far
has been
in-
accepted. Number two, your rules include them.
My lord, in my respectful submission, my lord, this point of ambiguity, if there is any, my
Has been
lord,
clarified by interpretation.
yes, my lord.
That means the interpretation of your finance department has to be reinterpreted by the court, whether the interpretation they arrived at is reasonable.
My
That's
lord,
only
the rule-
question.
my lord,
That
the
is
rule-
why, and so that is why we have to see whether your interpretation and whether you see a memorandum or your executive order will, can upset what the rules provide.
But on the
So
other
give
hand, my lord,
authorities-
if
what are the exceptions
my
where
lord,
it can happen?
if that is so, my lord, on the other hand, the petitioners will also have to show what is their right to draw the fifth pay commission. Rendering service, but they are not regular employees, my lord. They are not the regular employees. They are temporary employees.
No, but your rule says so. If they work charge also, what does work charge mean? You know what's the meaning of work charged? It's not work charge. Many people make a mistake of saying work charge, CRGE. It's work charged. That means you are charged against a specific
A certain
work.
specific work. Yes,
that's
I
it.
understand
And
that.
so you are given that work charge, your work charge employees. You have muster rules, you have casual workers, you have work charge employees, you have ad hoc employees, you have temporary employees, you can have contingent employees. So this is that the form of employment of temporary employment is like varied, and according to the requirement, you all make the appointment. So, and then the kind of duties work charge people upon work charge establishment may be discharged is different from a person in a contingent, different from a person who's allowed as a casual worker or daily wage. So that is why provision has been made in the rules itself, provision of pay rules, that they be given the benefits of the fifth pay commission by virtue of the kind of duties they discharge. And so now if you are to withdraw this benefit that you've been getting based on maybe circular before that we ban work charge employment after 1997, that means that the employment also is in question. You should terminate them now. You should terminate them now. Whatever they work for so long, that means the employment, the basis of the employment, if your argument is to hold, is that fine? Now they've been appointed wrongly. Sorry, here's your handshake, get lost.
My lord, in my respectful submission, my lord,
they should. 2009 pay revision, same wording.
It's a parameter. We have said that in our rejoinder also.
You bring authorities to show that
lord,
the interpretation.
As of today, I am.
We will reserve it. Otherwise, I'll give you one more opportunity.
Yes, my
as
lord.
usual, Mr. K. Parasari, we have to give him,
my
extended.
Lord, this is my lord, Supreme Court, my lord. On pay parity, my lord.
Pay parity.
Yes, pay parity, my lord.
This won't come. But this is a different. It's a unique situation.
Only on law, overcome the hurdle that if a notification can override a statutory provision.
You have to satisfy the court that. I'll give you time. Doesn't matter.
My lord, this is pay parity, pay scale, autonomous body versus state government, daily wage employees of respondent board, whether entitled to benefits flowing from the state government resolutions, necessity of adoption thereof by the autonomous body concerned. This is resolution. So, my lord.
See, out here it says that they are delinquents, and it said equation of post and salary is a complex matter. Granting of pay parity might lead to other people who shouldn't get the benefits be getting benefits. See, of course, you might have a point with regard to positive equality and negative equality. But negative won't come in also because others are not being paid. Only the ones before 97 are being paid. Yeah. Anyway.
Before 97, all of them are regularized. Now they are regular employees. They are no more work charge.
Okay.
My lord, the employees who are regularized are, my lord, employees who are prior to 1997.
So one question that, okay, rules are 309, correct? These revision of pay rules. Article 309.
My lord, if I draw my lord's attention to para 17 of this judgment, my lord.
Okay. I will reconvene at 2 o'clock. 17.
My lord.
Yes.
As per the settled proposition of law, equation of posts and salary is a complex matter which should be left to the expert body and undertakings, and the court cannot interfere lightly. Granting of pay parity by the court may result in a cascading effect having adverse consequences. There are limitations or qualifications to the applicability of the doctrine of equal pay for equal work.
Sir, this is totally a different. We are not talking about equal pay for equal work. Nothing of that sort. We are talking about whether by a memorandum you can take away the benefit which has been given by your rules. That's all. On the question that upon which it have been banned in 1997.
My lord, my respectful submission, my lord, because they are relying on that word which is work charge employees, my lord. They are saying that.
Why shouldn't they rely on it?
My lord, they are saying.
When it includes them.
Lord, that is why the finance department has clarified, my lord. Now, my lord, these rules, it is not a fact that, my lord, these rules have been modified after the filing of this case. This is not the case, my lord. These rules are in existence, my lord. Rule 15 clearly says,
the
my lord.
memorandum is in existence also.
My lord.
All the people after 97, they've come here before the court, or some of them are still
my
floating
lord.
around.
This is
My group is all from Jaintia, my lord.
My lord, post 97. They are all post 97, my lord.
You get that interpretation whether that allows you that latitude. It's a bit interesting in a way. Because the only foot in the door that you have is that interpretations allowed
Yes.
of the rules.
Yes,
and
my lord.
whether interpretation can, overcome the mandate of the rules and what the Fifth Pay Commission recommended, which you have accepted.
And my lord, the settled position of law is that interpretation comes only when there is ambiguity. Where is the ambiguity here? It clearly says work charge employee.
The
It was
ambiguity
intent of
is in the work
legislature-
charge, my lord. The intent of the legislative, my lord.
The ambiguity has been
the-
brought about
the-
by the circular, whatever saying is whether the actual entitlement, whether by the circular banning work charge employment.
So, my lord,
I'll give
my
you one proxy, just
my
settle on that point.
my lord, my respectful submission would be, my lord, the very word work charge, my lord, would mean and include only those work charge employees who have been appointed prior to 1997, my lord. Because post 1997, the government is not supposed to make any.
Then Fifth Pay Commission is dated when?
This is 2018. It came into
in 2000.
No, it came into effect on the 1st of March.
It was 13th of July 2017. Report was submitted 31st of July 2017.
And the revision of pay rules came 2018.
Yeah, 2018.
Yes. They take into account.
When a commission sits,
My lord,
all stakeholders are taken.
My lord, what the sub rule? If I draw my lord's attention to sub rule 2, my lord, what it says of the same pay revision, my lord. These rules shall not apply to
Yes.
A. Persons not in whole time employment.
Yes.
Persons paid out of contingencies.
Yes.
Persons paid otherwise than on a monthly basis, including those paid on a piece rate.
Contractual,
basis.
okay.
Contractual. Persons employed, next page, my lord, persons employed or contract except where contract provides otherwise. E. Persons re-employed in government service after retirement. Then persons belonging to All India Service. This is judicial service, my lord. Then I come to G. Any other class or category of persons whom the government of Meghalaya may, by order, specifically exclude from the operation of all or any of the provisions contained in these rules. So, my lord, I would rely on this, my lord, that they have been excluded. The work charge employees post 1997.
That's a new argument you're making. Under G, there's the order of the governor excluding them.
Will it still override the rules, the statutory rules?
No, it's the order of the governor excluding the application of the rules.
So
that means any order operates against them, that those orders of governor, because this is specific exclusion.
the only way out for them is to amend the rules.
My lord, the rules of I do not have it. My lord, the rules of
Do some
executive
research. There is do
the
some
rules of
research
executive business also gives powers to the concerned officers, my
Rule
lord.
15 as well as 2G,
Well-
which are both contradictory.
Yes, this for further hearing after 1 week. That's a matter to take at 2 o'clock or this.
If I may crave your lordship indulgence, in 53, your lordship, if this matter can be taken up next week, your lordship.
You ready today?
No, your lordship.
Then?
Next week, your lordship. This is our joint prayer, your lordship.
This is here there for the
petition.
Your matter will become structured soon, I think. Yes.
Next week, your lordship. Apply, your lordship.
2 weeks transfer prison since the matter is pending. Yes.
Item number 54.
Apply, your lordship.
Why?
54, my lord.
Where's Mr. Chicken Thigh? Is ready? He's there. At 2 o'clock.
You
I
want
thought they had a
support?
big fair this time.
Yes,
so who took the proceeds of the fair?
Already concluded, my lord. That
We
fair.
took the
Who
proceeds.
took the proceeds?
Daily proceeds of 3,50,000.
The odd fair. See, this is now you see that matters going on before the Supreme Court 9-judge bench with regard to whether resources, in public interest can be taken over. There's some resources or some assets which will serve better public purpose. So in this case also, I think
Similar footing.
not that. If that judgment comes out, let's see. Because it's the people, the kids are using it. That's the only thing.
We didn't say no. We have got papers to say we have been allowing it.
Anyway, yes.
Now they are enjoying the income from there.
Yes.
He wants some time. It's okay. 2 weeks
okay.
also?
Yes.
2 weeks.
51, my lord, I'll have to withdraw this matter, my lord. But the only thing is that, my lord, I am seeking some instructions from Mr. SD about the exact amount of money which was given to them to be paid to me. Well, ultimately, I'll have to approach the commercial. Just give me 2 weeks time, my lord.
Yes, Mr. K.H.S. Gautam says that we will have 2 weeks time to obtain instructions in this matter 51. Just after 2 weeks, yes. Om Prakash Rao?
Obligation.
Where's Mr. Jha? He's been waiting the whole morning. Yes, you ready?
Yes, ma'am. It is for them to take instruction with regards to the judgments which we have relied one from Uttarakhand, that disability pension, ma'am. I have a two.
But as the new law has come out now, disability pension. In fact, it's very interesting. I met one ex-colonel in my travels recently. So he also was, he was injured in IED blast. In Kashmir or somewhere, whatever. He's at a para commando or somewhere, or whatever. So he said that, he had a 60% disability. Even then, they were not granting him disability, he said. I had to fight, he said, I had to go to court and all my disability and,
AFT,
yeah, and then it was granted. But then I fought for the citation. I met him at the airport, he was that's the thing. What's the percentage of disability? 40%?
My lord, it's 50%, my lord. And the office memorandum, my lord, it says that because in army, my lord, he was a colonel, it has a different pension regulations, my lord. Here in the Assam Rifle Order, office memorandum say that even the disability percentage is not required, my lord, for grant of disability or invalid pension.
Yeah, the music.
10 days time.
Please come, otherwise these kind of matters.
Next day.
Yes, though objected to by Mr. Arjha on behalf of the petitioner, Mr. Dr. M. Mosika, please will out 1 week's time to obtain proper instructions. That's the matter thereafter.
Hello.
That's it. I don't completely done. Completely done? 50, I think, where's that lady? She must be interested in doing it. Yes. We take it at 2 o'clock?
Yes, Your Lordship.
Who's there for the respondent? Yes, 50. And then which other one?
Petitioner.
And petitioner, Your Lordship.
The main respondent is the Mr. Yobik from the management committee, whether he is here or not.
54 other party. Only your matter.
Yes, Your Lordship. Yesterday I received a copy of affidavit.
It may become next week.
Why?
Petitioner
Yes.
also-
What instruction did you give yesterday?
No, I've received the affidavit from the managing committee.
What does it
Your
say?
Lordship. It's saying that they have appointed her only for 20 days.
Appointed you for 20 days?
Yes, so many contradictions, Your Lordship.
So what do you want? You want to take instructions or you don't want to
No,
want
I
to hear
don't
the
want to
matter?
take instruction, Your
Let's see the
Lordship.
affidavit. Mark orders of the court. 22.
In serial number 3, Your Lordship.
One second. I was looking. Yes. Yes, Mr. Kalindo. How was he appointed low primary school? On what consideration?
Primary school, Your Honor, it's Your Lordship, is a deficit school.
It's a
No, no.
deficit.
How was she appointed there?
She was not appointed, but she came to approach the school.
Okay, whatever she came to approach, and you very generously appointed her.
No, we don't give her appointment or anything, but we just she said that she want to teach at the school voluntarily.
Yes.
So we admit her under in the 22nd February 2010. The school was upgraded to UP school.
Yes.
Thereafter, she applied the post on 8 March 2010.
Yes.
That the
So see that the case like this now, if you are taking her services, correct? Now first you are appointed in the lower primary school, upgraded that it ceased to exist, and then you had started upper primary. You called for interview, correct? Then as per effort she came forth, correct? And so she came forth. So all the 1, 2, 3 and her you allowed them to teach. Now just listen. Then you allowed them to teach, happily teaching. Then after the government started paying for 3 sanctioned teachers directly into the accounts, she had nowhere to go. So you didn't pay her anymore also. That's the only thing.
Your Honor, you allowed me or not?
Yes, of course.
That at first, when the salary came to the school, so we have adjusted. We have asked them
that was done, yes.
So we because we thought that the government sanctioned for 4 posts.
Yes.
But subsequently, after the school or the government said that we cannot sanction for 4 teacher, so we cannot. So because this school it's a mission school, at the same time it's a SAA school.
See,
we don't charge any fees.
This court understands. This court understands, Ms. Khanna, your difficulties, correct? But the fact remains is that you have taken the services of this lady, and whatever it is, because since the salary will be paid directly to the account sanctioned teachers, that adjustment where the whole money came to the managing committee and you could apportion to the 4 teachers, that is over. So that's the thing you left on the cold. Now you're not allowed to work anymore, correct? You're not working anymore.
No, I'm still teaching, Your Lordship.
Okay, still teaching, whatever. Okay.
Yes, I'm still
She's teaching like that without any against a 4th post which doesn't exist, with all 3 sanctioned teachers, and so this post becomes like a private employment of the petitioner by the managing committee. Correct. It amounts to that. If you are availing of our services, so how much are you going to pay as a compensatory package?
For now, Your Honor, after COVID, at the same time also the school did not charge any fees from the student, or we don't have funds. So that's the difficulty we have now.
Then you have to consider humanity. Maybe on law she has no case. Maybe she applied, but the very fact that you allowed her to enter into employment, initially, before it was still lower primary school, after a few months became upper primary, that's besides the point. But the very fact you allowed her to continue and you paid her, that means you found her fit to continue if you pooled the resources and you paid her. Now what do you do with her now? Poor thing, she's teaching. Now because 3 sanctioned teachers, she came forth, she'll be left on the cold. You give her something? Initially, we were not going to consider a case. We thought since you're 4th, so on and so forth. But now looking into the fact that now since 2010, she's been helping your school. If she must have been found fit by you if she's teaching 2010. Now 2024. Now you're not getting paid, nothing.
No, Your Lordship.
You're just going to school every day.
And now I'm about to attain the age of 40. I will not get any job anywhere. And I have 5 minor children.
The teacher, she must understand that
what resources do you have?
We don't have any. We don't have other sources. Your Honor.
Nothing. How many students do you have in your school?
We have around 50 students.
You don't charge any fees? Is that
no,
a fact?
because a school is not allowed also.
Okay,
RTE is not allowed.
So what do you do with the services then?
So we can let the managing committee decide on her. we can pay whatever we can decide.
Yeah, at least
honorarium.
bring, yes,
Honorarium.
Honorarium or something. You decide, because that is the sad aspect of this case. Person was not properly appointed. He came forward.
But to give him a salary of like she expected,
no, you can't
we
get a
cannot
salary.
do that.
She's not entitled to a sanctioned teacher salary. Also, she's not a sanctioned teacher.
And we
certain
have
schools, you see, what did we keep other teachers? Then they pay from their own resources. What congregation is this?
This is a congregation is diocesan.
It's a Catholic school.
It's Catholic school. It's
Catholic
RCUP.
school.
RCUP.
Catholic schools are very well funded.
No, they have not because that is funded. Also, we don't have fund.
Why? I come from a Catholic institution.
But this school in this parish,
school in a Catholic institution, they're very well funded.
No, but Your Honor, in a parish, we have because it's a rural area.
That's why
we don't
parish
charge
supports
anything.
the school, Ms. Khalindo. Correct? Yes or no? The parish supports the school, correct?
Yes, even in this case,
Yes or
Your
no?
Lordship, it is
Yes.
clearly mentioned.
That's why you take a call.
We will take instruction.
You give us something compensatory package, and you can wind up a service.
We can do
Yeah,
it.
take down. Affidavit has been filed by the respondent number 5 managing committee, showing that as the funds for a fourth teacher had become unavailable, the petitioner who stated also does not possess a minimum required qualification was no longer paid by the management, by the managing committee. However, next part, this court notes that the petitioner entered into service with the school on an honorarium basis with effect from 8 to 2010. And thereafter, after the schools upgraded to upper primary school, continued in the service, Stop. The other of the current service, though she was not a sanctioned teacher, was paid a salary by the state government. Stop. Next paragraph. Notwithstanding the fact that the petitioner, you're not qualified, you don't have the qualification.
I am well qualified, Your Lordship. That's why I want to go for a proper hearing so that I can show that I was a sanctioned teacher. Because when we go through the case record, Your Lordship, they have mentioned the advertisement of 2 sanctioned teachers. But 4 sanctioned teachers were there before.
No, now 3 sanctioned teachers. Now, private schools have 3 sanctioned teachers. There's no other SSC.
And my allegation in my petition, Your Lordship, that manipulation has been done.
In the selection?
Manipulation has been done, yes, Your
selection?
Lordship. In the selection.
Selection happened in 2010.
2010, yes.
Then you can't, that you can't. We'll address it in your thing. Anyway,
Yes, Your Lordship.
Notwithstanding not poor understanding, the teacher, the petitioner, having served for a number of years, is therefore entitled to some consideration. Stop. Mr. Kiwi Kharindo to obtain instructions on next date. Otherwise, you see, selection that's over. You forget about it. You can't claim any right on that or derive anything or challenge it. It's just that otherwise, very unfortunate, but what to do? Just after you get instructions.
And Your Lordship, I'm well qualified and I have a degree and a B.Ed. So I'm well qualified.
No doubt. Now you're 40.
Why
don't you go and apply to other schools then? That time? Once you apply in other schools, if you have a B.Ed, when you are still eligible. Yes. Obliged.